Welcome to Between Two FARS. I'm Warnicki Miller, here once again with Ed Fein, who has been our patent attorney and our intellectual property counsel for quite some time. In 1986 he became our patent counsel, but he has been working for NASA for 52 years. And today we're going to talk a little bit about IP rights in R&D contracts versus other contracts. So let's start out with like a lawn mowing contract. What type of IP rights would we expect to see in a services contract?
None.
Nothing at all. We're not even going to worry about it, right?
No.
Okay.
No. I mean, if it's roads and commodes contract, there's not going to be any new technology. There's not going to be any inventions coming out of that. So we don't put any clause. It'd be superfluous.
Yeah. And then we talked a little bit about your traditional R&D contracts before, but what about those ones in the middle? Maybe we've got an engine we've been using for a while, and we want a company to come in and take a look at it and use what we've got and see where it goes from there. What sort of intellectual property rights do we need to worry about there?
We put the same ones in as R&D, because if you're going to have engineers performing work under the contract, there's a possibility that they could come up with new technology, and we need to capture that. We need to delineate rights between us and the contractor in those kinds of contracts as well.
Okay.
So there should not be a distinction if it's a tweaking contract versus a full up R&D brand new stuff contract.
Okay, so if you're an attorney and not a patent law attorney, not an IP attorney, but just one of these, run-of-the-mill procurement attorneys who's looking at...
They are not run-of-the-mill.
Who's looking at something that our clients want to buy. How do we know when it's time to go and say, hey, I think we need to talk to an IP attorney about this? What are some of the signs in the factual scenario that we should look for?
We have Part 12 of the FAR, which is for commercial goods and services. I think we need to be very careful because we do procure a lot of services from engineers, and when I think of commercial goods or services, I'm thinking of going to Best Buy and buying a television or a computer. And when you buy a computer at Best Buy, you're not going to get enough data to replicate that computer. You're going to get a user's manual. So those are the kinds of contracts. If we're just acquiring commercial goods or services, we really, the FAR says no IP clauses in those kinds of contracts. We kind of fudge and put data rights clauses in them because we often need more data than you would at home to run a computer. So, but the bottom line is that if they're going to be doing innovation or development or engineering, if there's going to be engineers working on the contract and using their technical side of their brain, we should have patent rights clauses, data clauses in the contract to capture the delineation of rights between the parties.
Excellent. Well, you heard it here, guys. If we've got engineering in our statement of work, might want to get an IP attorney involved.
Yeah, we're here to help.
Ed mentioned data rights, and I think we need to come back next time and talk a little bit more about that. So please join us for our next episode of Between Two FARS.
Thanks, Warnicki.